So another New York concealed carry case is up at the Supreme Court level seeking review. So let's talk about this. Also want to give a shout out to the sponsor of this video, which is Established Titles. Have you ever been watching Game of Thrones and thought to yourself, man, I want to be a lord or lady? Well, with Established Titles, you can. Through Established Titles, you get 1 square foot of dedicated land on a private estate that's in Scotland, and you get also a printable certificate with a crest recognizing you as a lord or lady. Here's actually the certificate that they sent me. It says that Lord Anthony Miranda has my plot number here on here as well. So when you order one of their packs, you get this nice little plaque here and this nice little piece of paper that shows that you are a lord or lady and also the plot that you have in Scotland. So I guess because of this now, you guys can call me Lord Armed Scholar of Scotland if you want. So really the intention of these packs is to provide a fun novelty product for those who want to purchase something a little bit different for themselves, for their friends, or for a family member. And simultaneously, in purchasing this product, you also are protecting the woodlands in Scotland. This is a great last minute gift idea, especially with the holidays coming up. It serves as a good stocking stuffer. And also, if you purchase one of the couples pack, you can actually get the adjoining plots in the same location. And Established Titles told me that for the first 200 people who purchase a title using my code, you will get the plots right next to mine. So we can build this little Armed Scholar community of our plots there in Scotland. If you're interested, you can use the link down below and make sure you use the code ARMED for 10% off. So thank you again, Established Titles, for sponsoring this video. How's it going, everyone? My name is Anthony Miranda. I am a licensed and practicing attorney in the state of California with an emphasis on Second Amendment rights. I've been part of Second Amendment litigation both at a state level and a national level, while serving as a staff attorney with the Firearms Policy Coalition legal team. My goal with these videos is to not provide any legal advice, but instead to give you insight into the inner workings of Second Amendment litigation and what's currently going on in the Second Amendment battle and our battle for our rights to keep and bear arms. As I mentioned in the intro, in this video, we're going to be discussing another New York concealed carry case that is currently seeking Supreme Court review. The case we're going to be talking about in this video is Baldia v. the City of New York Licensing Division. This case arises out of the old standards that New York and the City of New York used to institute in regards to granting and denying concealed carry permits. Now, for those not aware, there was a prior case which has already struck down this old New York may issue permitting scheme, and that was the New York State Rifle and Pistol Association v. Bruen decision. The state of New York used to require a person to provide proper cause to be issued a permit to carry concealed. The issue was that the state of New York did not ever consider self-defense a proper cause, and therefore on that justification alone, people had their permits denied. In a 6-3 opinion authored by Justice Thomas, the Supreme Court reviewed this issue and struck down this old New York concealed carry may issue licensing scheme. In that opinion, Justice Thomas stated, "Today we decline to adopt the two-part approach. In keeping with Heller, we hold that when the Second Amendment's plain text covers an individual's conduct, the Constitution presumptively protects that conduct. To justify its regulation, the government may not simply posit that the regulation promotes an important interest. Rather, the government must demonstrate that the regulation is consistent with this nation's historical tradition of firearms regulation." So in the Bruen decision, the Supreme Court struck down New York's may issue CCW licensing scheme, finding that it was inconsistent with this nation's history and tradition. In response to this decision by the Supreme Court, instead of rolling back their concealed carry laws, the state of New York essentially doubled down on their gun control and created a scheme that's even worse than the one that existed prior to Bruen. This new law in New York created a more restrictive application process and then made it so that almost everywhere within the state is a sensitive place, effectively making your permit useless even if you get one. That new change in law is being challenged currently in multiple cases, right now including the Antioch case, which we've covered at length on this channel and we've talked about. However, this case, Baldia, is a carryover case from the old New York may issue and proper cause standard. The plaintiff in this case has filed a pro se writ of certiorari to the Supreme Court, which means he's essentially representing himself and he's seeking Supreme Court review of this issue. Mr. Baldia applied for and was approved for and was issued a restricted business carry license by the licensing division back in 2012. And later he was subsequently granted renewals and multiple expansions of his privileges under that license, eventually resulting in an unrestricted status because he demonstrated a proper cause. At the time when he was issued the restricted business carry, he had created a company that provided health strategies and equipment to police officers, so that is kind of the relationship he had with police officers during his initial application and granting of the permit. Now, during the whole shutdown of our nation, Mr. Baldia was hired by a municipality near his own home and became an active sworn police officer. So he became law enforcement and he was a law enforcement officer. Now, again, the facts are a little bit blurry with this case because he did write this petition pro se. So sometimes that happens where they leave out pertinent information. So it's kind of hard to understand fully what ended up happening. But from what I can gather is that Mr. Baldia applied for his permit to be renewed and was seeking again for an unrestricted carry permit under the justification that he had proper cause to be issued an unrestricted permit to carry concealed because he was a police officer. However, his renewal application was then denied, and it was denied on the basis that the licensing division believed that he did not have proper cause to have an unrestricted concealed carry permit. In reaching that determination, the licensing division found that Mr. Baldia is not in danger in the same way that someone like a diamond dealer would, who walks down the 48th Street with a briefcase of precious diamonds, so he's not at the same risk that someone like that would be. And on that basis, they denied his application, his renewal, and they denied the unrestricted concealed carry permit. He then sued for reconsideration of that licensing division determination, since he argued that their decision was arbitrary and capricious. This case then made its way through the appellate process, where the courts found that the denial of his renewal application was not arbitrary or capricious. The court found that the licensing division rationally concluded that his application did not establish proper cause for the purposes of the application. And that resulted in this case now being before the Supreme Court and Mr. Baldia now seeking Supreme Court review of this issue. The main question he presents to the Supreme Court for consideration is whether the licensing division is empowered to deny an unrestricted concealed carry license to a qualified police officer who seeks to apply for such licensing. Now, since this case is a carrier review of the prior proper cause standard, I see this really going one of two ways. First, I have no doubt that the licensing division, the respondents here, will file their response and will argue that this case is now moot because of the Supreme Court's prior ruling in Bruen and subsequently the change of law in the state of New York. Again, like I mentioned, the state of New York changed their concealed carry laws. They passed the CCIA, so this whole proper cause standard is gone and they have a new standard. Now, this new standard under the CCIA is no better, it's even more restrictive, but the laws have changed. So the state will likely argue that the proper cause review and this standard no longer exist, and therefore this case should be denied as moot. Another route this case can take is that the Supreme Court can simply GVR the case in light of Bruen. And essentially what a GVR means is that the Supreme Court can grant review, vacate the prior decision, and remand the case back down to the lower court for reconsideration in light of their Bruen decision. Whether that will happen, I'm not super confident of that. I can see the Supreme Court simply denying cert in this case and Mr. Baldia likely needing to refile a new case using the new Bruen standard. And also, he will likely have to try to apply for the new carry permit under the new carry permit system under the CCIA to be able to challenge that because, again, this whole proper cause standard has now been eliminated because of the change of law and because of the Bruen decision. So this is an interesting case because it shows how absurd the prior proper cause standard was, based on the fact that even a police officer in the own city of the city of New York was not qualified enough and did not have a good enough justification to be granted a carry permit to carry concealed while he was off duty. So if you guys have any questions, go ahead and comment down below and I'll try to answer the best of my ability. Also, you can ask me questions like a lot of you guys have been asking me. Some of you have been asking me about the guitars behind me, what they are. I have one acoustic Epiphone that was my grandfather's. I have another guitar that's kind of a no-name brand. It was one of the first guitars I ever had. And then the other one is an Epiphone. It's an SG clone. So, and a lot of you guys have been asking me to play on video. You definitely don't want to hear that. I am not a good guitar player at all. I'm trying to learn. So some of these were my grandfather. Some of them were my dad's that were given to me. And now I'm trying to learn. So maybe one day when I get better, you will hear me play on video. But just right now, it's probably not going to happen. So if you guys like this video and support the channel, one of the best ways to do that is to like, comment, and subscribe. All those things help to fuel the algorithm or fuel Algorit's rhythm. It adds fuel to his jet and signals to YouTube that you guys see value in these videos and in this type of two-way news. Again, I want to thank everybody who likes, comments, subscribes, who hits the notification bell, who shares these videos. You guys directly impact these videos, impact this channel, and help me to reach and educate more people than I could ever do on my own. So as always, thank you all for watching. Don't forget to like and subscribe. And never forget, this nation was built by armed scholars, and this nation will be maintained by armed scholars.